Alrighty, folks, looks like we are live. I'm George. I'm one of the founders of SoloSuit. Go ahead and let me know if there's any issue with our audio and visual. Looks like everything's working all right. So that is fantastic news. Good to see all of you. I'm going to be going over the basics on how to respond to a debt lawsuit. I'm just going to go over real quick usage on our site and run down a few of the main steps that a lot of you folks are probably wondering about. And then we'll reserve most of the time for this show to answer any questions that you have. All right, so if you have any questions, just go ahead and put those into the chat, and we will go ahead and do our best to respond to them. All right, just a quick disclaimer as we're getting started. I'm not a lawyer. I'm not your lawyer. SoloSuit's not a law firm. We're not your law firm. We aren't providing legal advice. This is just a webinar. Alrighty, and I'm just saying those things just because of regulations. All right, that said, I'm here to help you out. All right, so most people are on this webinar because they've been sued for a debt, and you can use SoloSuit to resolve your debt lawsuit. Alrighty, let's see. Great. So here's our website. You can check it out on your phone. Most people will use it on their phone. You can do it on the desktop, whatever. You can just come here, solosuit.com, click reply to a debt lawsuit. And you can check out our cool reviews. We got 4.7 stars out of 578 reviews now. We love more reviews, so if you've had a good experience with SoloSuit, please go ahead and leave us a review on Google or on Reddit. If you're on Reddit, we'd love to get more reviews on Reddit as well. See, we've been featured by Fast Company, NPR, Bloomberg, TechCrunch, even ABC likes SoloSuit, so that's great. You can choose from the premium package or the standard package. So to respond to the lawsuit, you can do the standard at $67. You'll be able to create your document, and then we will file it for you in court. Basically, the software will file it for you in court. It takes 1 to 8 days to file. A little bit about that. Sometimes it's 1 day. That's only if your court is set up for e-filing. We only e-file in states that have good statewide e-filing systems. That is not most states. Most states have super weird e-filing systems that vary from court to court. So we only do it in some states. For the standard, we're going to be sending your document usually by 3 to 5 day US certified mail. All right. And then basically how fast we get that done oftentimes depends on how well you fill out the form online and how responsive you are to our emails if we need additional information from you. All right. The premium package, which a lot of people do, is $247. It's a sweet deal compared to an attorney, right? A litigation attorney might charge like $30,000 just to get started on your case. You're going to get all the stuff that's in the standard. However, the main thing is you're going to get faster filing, and you're going to have an attorney review. Okay, so we will file it by 2 to 3 day. Usually it's going to be 2 day USPS priority mail. Then we're going to have an attorney review the documents, usually a written review. The attorney is going to check out the complaint and summons alongside with your answer, make sure that you didn't do something like inappropriate based on your responses on the website. All right, so oftentimes the attorney does catch something and really ends up saving someone's case. You might ask, why do we use USPS? Why aren't we filing by FedEx or something like that? We use USPS because most courts, a lot of courts at least, require filing in a PO box. And the only mailer that can file in a PO box is USPS. So we have to use USPS. And oftentimes USPS works right. All right, then you can check out some of our reviews. Let's take a little quick peek. Some of our reviews here. Morris Mills mentioned that it's $247 plus court filing fees. A very good point, Morris. In some states, there is a filing fee. About 25% of states across the U.S. charge filing fees. California and Minnesota are some of the more populated ones that charge filing fees. And those range for anywhere from like a few dollars to several $100 in California. In California, the courts there will charge you $455 just for the pleasure of responding to your lawsuit. Right, if you don't like that, I encourage you to write a letter to the Supreme Court of California or maybe your congressional representative in California and change that. We think that's pretty crazy that they're charging you money just to respond to a lawsuit that you didn't want to be in. Right, that's what California does. They're charging you a lot of money. to just respond to the lawsuit. Thankfully, we're able to automatically calculate the filing fee, which is quite difficult to do on your own oftentimes. So with either of these packages, we'll automatically calculate the filing fee, and then we'll transfer that fee to the court for you so that your document's accepted. We got a nice review from Jill Gold, a great source of information with accurate documentation needed for most court case needs. Great. We got a review from Justice. It's a pretty sweet name. The steps are so easy to follow. Great job. Great. We got a review from Michael. Excellent service. I'm very impressed with the quality of the service. Crystal said, made it easy. All right, there we go. Got some nice reviews in there. And so far, if you're wondering if Solo Suit's legit, we are legit. We've helped people respond to over $1.3 billion across the US. Helped over 214,000 people to date. All right. If you use us, we might get up to 215,000 pretty soon. So that's fun. All right. And then, what does it look like once you're in here? So you'll click the Get Started button. You will make an account. You'll just make an account real quick. Let me arrange that. All right, so you just make an account, and then you'll be asked to confirm your email. You don't have to confirm your email. We just need your email and your password for the account. It'll tell us what state you're in. Let's say you're in California. And you can choose one of these packages. And then you will go on and just tell us about the case. You answer some questions. You'll give us information about the case, and then you'll have a chance to respond to every paragraph in the complaint here. And then you'll be able to make your defense. So you'll be able to make some assert your affirmative defenses, and then you'll be able to file the document through the software in court. All right, so that is the quick rundown on the answer. A lot of people want to settle. So once you complete this, you'll come out to this page, like the documents page, and you'll be able to try Solo Settle. So if you want to make an offer to settle to the collector, not for everybody, maybe you don't want to settle. If you do, you can just come over here, answer a few of the same questions, then you'll tell us how much you're being sued for, you'll tell us how much you want to make as an offer, and then you'll enter in a structured negotiation through the app. Once you agree on the terms, the collector will send you the settlement agreement, and then you'll be able to sign that on the app, and then you'll make a payment, transfer it to the collector through the app. You can even do monthly payment plans on here. If you want to try to settle for like $100 a month over 3 years, that's something that you can do. All right. So that's the quick rundown. Now we're going to go ahead and jump in to the questions. We got a lot of people watching, so if you got a question, go ahead and put that into the chat. I'm going to try to get to all of them tonight. We got a little while left. Usually end about half past the hour. So let's go ahead and jump into things. All right. I am back. Just had to grab my little pencil. That's exciting. Letting the kids play with the iPad there for a minute. But now it looks like it's all set up. Okay, great. We got a question from Morris. If you have been summoned to court by the collection agency and there's an arbitration clause, it looks like you said aberration clause, but I think you mean arbitration clause, in the credit card, does the debt collector have to follow the rule? Okay. So you're wondering about an arbitration clause. Let's go ahead and see here. Ah, okay. So you're wondering about arbitration, right? So a lot of credit card contracts have an arbitration clause in them. We have some videos about how to find them. The CFPB has a great database of most credit card agreements. You can just open one up and then you can keyword search like Command F, the word arbitration. Try to find that clause in there. If yours does have one, usually they're pretty much the same. It'll usually require the plaintiff to pay for arbitration. Either party can initiate or require arbitration to be initiated if there is first like litigation that's started, or if they just want to go right to arbitration. And that's the general idea. So oftentimes those clauses are in there so that if somebody sues the bank, like if you have a Chase card and you sue Chase, Chase can force you to go to arbitration to keep the litigation private and hopefully keep costs lower for both parties. Uh, However, since it's in there, you also have the right to trigger arbitration as well. So if they sue you, you can say, I want to go to arbitration. And most of these clauses will require the plaintiff to pay for it. Usually, if there's an option for jams, it's good to go with the jams. That's a little bit more expensive than AAA. AAA is going to be a little bit of a cheaper option. I was just talking with a VP of AAA at AAA the other day. Great dude. He was talking about how they like to do arbitrations for consumers and how it can be beneficial for folks. So there's that. So then you can enter into arbitration. There's a fair chance a lot of people do this so that the collector won't actually uh, go to arbitration. They won't want to pay for it, so they'll actually just drop the case and not pursue arbitration. So that's what a lot of people are aiming for. Doesn't always work. Sometimes the collector actually will proceed with arbitration. And then if that does happen, then you have to kind of initiate the private arbitration process. You probably receive some instructions on how to do that. Generally speaking, like you kind of go on to AAA's website and do some stuff, and then you'll go before an arbiter instead of a judge, and they'll make a decision on your case. All right, so that's the general idea. If you do want to trigger it, you can file a motion to compel arbitration, which you can generate on our site. Lynn Lyon, here in Wisconsin, it sounds like. If a private health agency receives state funds, can the state attempt to collect the debt 8 years later? So this is a statute of limitations question, also abbreviated to SOL. The question is, are you SOL or are you not? Or rather, is the collector SOL? Who's to say? So we have a calculator on our website that you can go and check out. I think if you search like statute of limitations calculator solo suit, should come up. We have all of the laws for all 50 states loaded in there and all the different use cases and types of debt. So you can enter in like what kind of debt it is, what state you're in, when was the last date that you made a payment on the debt, and you can find out. It really depends on the state. As far as Wisconsin, it's not a state. I don't talk to a whole lot of people that are in Wisconsin. Of course, we have plenty on the site that are filing in Wisconsin. I'm not sure if it is 8 years or not. Maybe we could just try to take a quick look together. I haven't used the calculator in a little while. Let's just take a look here. Alrighty. So you're going to select your state. So Wisconsin, this is our statute of limitations article. It has a nice picture of a lovely family here at the beginning. Then you have the calculator. You're going to enter in Wisconsin. Let's say private health agency receives state funds. I'm not really sure what we're talking about here with state funds. Maybe let's say it's like a student loan or something. And then 8 years later, so let's say you made a payment in 2016, that's about 8 years ago. So let's peg at May 1st. Let's calculate. It says the statute of limitations has expired. Alright, so here we go. Statute of limitations calculated. We did it. Statute of limitations for student loan debt in Wisconsin is 6 years. Statute of limitations expiration date is April 30th, 2022. Exceptions and nuances may apply. Should check your state's law to be sure. Right. So then you can go ahead and, so it's saying it passed in 2022. That's like the last date they could sue you for it. They can still try to collect the debt from you. But they won't be able to sue you if the statute of limitations is expired. Of course, what that means is that they can sue you, and you will lose unless you respond and say, the statute of limitations is expired, I should win this case. Okay, so nobody's going to stop them from suing you if the statute of limitations has expired. The only person that's going to stop them is you by filing an answer document. Very important concept. Okay, if you don't respond, you will lose, and then you will actually owe the debt, even though the statute of limitations has expired. So you need to bring this up as an affirmative defense in your answer. We make it really easy to do that on our site. You can check out the state law. Don't be shy. Don't be afraid of the laws. Reject those cookies. No cookies for me. And here you go. Except those yada 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 shall be commenced within 6 years. This is our friend site case text acquired by Thomson Reuters recently. It's a friend of ours, Jake, made this company, and he has a lot of great legal resources on it. It's a really good website. All right, so that is the quick rundown on that. All right, jumping back into the questions. Let's see, we got 10 minutes left. I'm gonna get back into them. Okay, we got Project Deus. Nice. If I used solo suit to reply to the suit and haven't heard back, does that mean they're proceeding with the suit? Yeah. So let's take a look at the old iPad. All right. So most people come to us when they get the summons and complaint. We're just going to say the S and C in the mail, or they're served personally. When you get summons and complaint, you got to file an answer. Otherwise, you will automatically lose. You can use solo suit to file the answer. And then most people, after that, they want to settle. Settlement is usually the best option. On average, cases on solo settle, our platform, settle for about 71%. It's pretty sweet. You could delete quite a bit of debt in just like a couple days if you successfully settle. And you can use our tool Solo Settle to do that. That's what I showed you on the website earlier. And let's see. Not everybody wants to go down that route. And then Project Deus is asking, so he filed an answer and he hasn't heard back. What should he do? So it basically could mean anything. They could just be waiting, and then they're like waiting, hoping that you're going to move, and then they'll serve you at your old address. You won't find out about it. Like, they'll serve the next document, like a motion for summary judgment, at your old address. You won't find out about it until it's already decided on, and you lose your case. That could be something that they're trying to do. It's pretty sketchy. Not definitely not all debt collectors act like that, but some do try those tactics. They're probably not going to do anything in less than 30 days, right? Unless it's been 30 days. The law firm's probably going to take about 30 days to do pretty much anything. So I wouldn't expect to see anything happen before then. And they could file for discovery next, right? They could go for discovery, in which case they'd send you like a request for admissions or interrogatories. We don't really help out with that stuff. We're mostly focused on helping people settle, but there are resources online that will help you understand your options there. And then motion for summary judgment and MSJ is another option. So they might file a motion for summary judgment, which asks the judge just to make them win pretty much automatically at the beginning of the case without hearing your side, just because you don't have a defense. So that's something that they could file as well. Those are kind of the main paths from filing the answer. Most people want to settle, and a really good time to make an offer to settle is right after filing an answer. All right, Franco. I use solo suit to respond to the lawsuit. Now I have a court date for the next month. Now what do I do? Yeah, you can watch our videos on how to prepare for a court case. We have some videos on our YouTube channel. There's one where I'm in a nice suit. I tell you how to prepare for court. Just generally make sure you have lots of documentation and get all your records together. If you already paid the debt, make sure you have really solid written proof of that. If you're trying to win by making it clear they can't prove that you owe the debt, then you can just come and make that defense saying the burden of proof is on them. They have to prove that you owe the debt. All right, we got 5 minutes left, so I'm going to go ahead and try to go a little more on a rapid fire lightning round now. All right, Franco Physique. I use solo suit to respond to a lawsuit. Now I have a court date for next month. Nope, we already answered that one. We got Mark. Your service rocks helped me with 2 suits, and it was super easy. Thank you. Thank you, Mark. Love when people come on and let us know that we did well by them, so that's great. Glad we could help you out, Mark. Sylvester, can you file in Illinois? Yes. Morris Mills, $247 plus the court filing fee. That's right. Mark, what do you do if the attorney suing you will not respond to the direct communication and also will not provide you any info on the debt? A little bit tricky. If they filed a complaint against you, make sure you file an answer. You can try recording your communication. Oftentimes you can bring this to a court case and show that the collector acted in bad faith and wasn't willing to settle with you. And sometimes judges do respond pretty well to that. And then if they aren't proceeding on the case, you can file a motion to dismiss for lack of prosecution. Terrence Power, I filed the answer and the court responded with an order for mediation. I called the law firm to schedule and choose a mediator, and the gatekeeper responded, we don't give legal advice. Yeah, that's super common. So basically, like, the standard answer for anybody when you're trying to get legal advice is for them to say, we don't give quote unquote legal advice. What that means is it's basically like legal advice in quotes, saying they are not providing legal advice because they aren't attorneys. Regulation prohibits anybody from providing legal advice that isn't an attorney. So I wouldn't really worry about that. It's like super standard response from people that work at courts. And yeah, just go ahead and get that. Just go ahead and get that document filed, or the mediation initiated. I think is a good way to go. Oh, okay. And then let's see. Where am I? If I apply for a filing fee waiver from court and approved, can you still file it? Yeah, we can file for you after you have a filing fee waiver. Basically, you just want to email us and let us know that. We also provide the filing fee on our site, and we will file it for you with your answer if you'd like. Jim Bob, I used the $29 solo suit option to respond to a debt they never disputed. In fact, they reported it as collection charge-off during the 30-day period requested in the letter. What was my next step or package? Yeah, so it sounds like you're pre-lawsuit and you used our debt validation letter to respond to a collection letter. If you were sued, you definitely want to use our answer document to respond, not the debt validation letter. If they validated the debt, which it kind of sounds like they did, then you can make an offer to settle, right? If you owe the debt, best resolution for you is probably going to be to settle it. It settles for 45% on average pre-lawsuit. So debts pre-lawsuit settle for more than debts post-lawsuit. So now would be a good time to settle. BGov. After they answer your interrogatories, what do I do next? There's no court date set in NYC. Just monitor the docket and get ready for a court date to get set. Myrna, can I sue my debt consolidation firm that's supposed to settle my debt? Suddenly I have a summons. I did everything by myself because the law firm won't answer me. Sorry to hear about that. We get quite a few customers that are in that position. We partner with some debt settlement firms. We offer our own debt settlement service. It can be a hard thing to figure out how to help people to respond to these lawsuits. I'm glad that you're using us to respond. This is a tricky situation. Can you sue them? Probably, yeah. You can basically sue anybody for any reason whenever you want, right? That's like how it works in America. You can just file a lawsuit against anybody. Question is, will you win? Probably not. Their contract's probably pretty good. Probably wouldn't win against them. But maybe. I mean, most debt settlement firms, if you search if they've been sued, they probably have been sued. A lot of debt settlement firms get sued by the Consumer Financial Protection Bureau pretty regularly for class action lawsuits or something else. So you might want to look into a record of litigation against the firm that you were using. Jade, what if you're being sued but you have your debts with a debt relief company settling them and already making large monthly payments? Yeah, you can use us to settle. You can use us to respond to the lawsuit still. And if your debt is enrolled with the settlement firm, just let them know you're using SoloSuit. A lot of their customers are probably using us. Jake's Jam, received the order to mediate. The document says the plaintiff, LVNV, will contact you. I settled for a small suit with LVNV, but I feel I didn't get a very good deal. The suit is for $900. Okay, sounds like you're all wrapped up. Yeah, maybe you didn't get the best deal, but there really isn't. I guess compared to some of our customers, $900 isn't a very large amount. So maybe you just want to get that paid and walk on and enjoy the rest of your life. Joanna, does statute of limitations freeze when case is left pending in court for debt collector? The statute of limitations is calculated from the last date that you made a payment on the debt. Okay. Ashley Harp, default judgment in 2019, garnishment summons 2024. Just filed a motion to set aside default judgment and garnishment exemption. Can I win? What do I need in defense? Yeah, so you got default judgment in 2019. If you never responded, a motion to set aside judgment can be a good option. This is super late, but maybe the judge will accept it. You can still try to settle even after your wages are being garnished. TH said the statute of limitations for law in NYC is now 3 years. Maybe you can check out our calculator. I'm not super sure. Okay. And then Anetta, what happens if court dismisses my case? If your case gets dismissed, you want it to be dismissed with prejudice. That means that they can't sue you again for it. If it gets dismissed without prejudice, that means that they can sue you for it again. And it's not, it's not a double jeopardy situation, unfortunately, but they can't sue you again. They can also try to collect from you even outside of court. So if you legitimately owe the debt, they might still try to collect from you outside of court. Dismissal isn't the same thing as winning. It just means that the case was withdrawn from court. But it can feel a lot like a win for a lot of our people. 90. How do you answer interrogatory questions? We have some blog posts on it. You can check it out. Just search SoloSuit interrogatories. That'll help you out. All right, last question here. Dan Noodle. My identity was stolen and a credit card was opened under my name. Now the debt collector is suing me. What should I do? I have sent them the police report before, but they don't seem to care. Okay, yeah, really unfortunate situation. Just stick to your grounds. I definitely wouldn't settle something if I'm being sued erroneously, right? So if you've been sued, make sure you file an answer. You can bring it up on our site that you don't owe the debt, and then just work your way to get to a court case and bring that police report, and that should be really good evidence convincing before a judge that you don't owe the debt. If you can really communicate that correctly to the collector, they should back off. Sometimes it's just a matter of like getting it to the right person inside that firm. You can try making an offer for like $0 on Solo Settle. That's an option as well. Okay. All right, folks. Well, we are now half past the hour. So that is the conclusion, the bittersweet conclusion of our webinar today. Very good talking with you all. Glad we could help you out. Remember, SoloSuit is in your corner. All right, we are striving night and day to help you guys out and get you all better outcomes. So I'm glad that you're here. Glad we could talk to you.